Well, welcome all. Thank you so much for agreeing to participate in our first joint Mentor Network topic discussion on IP protection and strategy. My name is Mani Garashi. I'm your moderator for today, as well as head of strategy at Launch Tennessee and a former Silicon Valley entrepreneur. Glad to be back home in Tennessee. It's my honor and privilege to introduce our panelists for today, who will give a little bit of a background on themselves. And I want to extend my sincere thanks to Dr. Maha Krishnamurthy, Vance Van Drake, Platt Boyd, and Jim Stefancik. And so maybe we'll go in that order and let our panelists introduce themselves. So Maha, do you want to kick it off, please?
Yeah, hi, and thank you so much for having me. It's a pleasure to be here. And so Maha Krishnamurthy, I am the Vice President of UT Research Foundation. So we're the Tech Transfer Office of the University of Tennessee. My office primarily focuses on the Knoxville campus. Our sister office is in Memphis and is headed by Richard Maggot. And we do everything tech transfer. And the primary mission of UTRF is to essentially commercialize inventions, grow the research, develop and create an entrepreneurial culture at the university, and then to lead all of that, hopefully leading to economic development. So glad to be here.
Thank you, Maha, for joining us. Vance, would you like to go next?
Hi, my name is Vance Van Drake. I'm a patent and IP attorney at Ulmer & Byrne. I'm secretly an entrepreneur. I've co-founded 3 companies myself. I do some angel investing as well through a group called Kinetic Ventures. And here's a shameless plug for my book, The Patent Game, that I wrote specifically for entrepreneurs, because I ended up saying the same stuff over and over and over again. It's a lot cheaper for you just to buy a book. So happy to be here.
Thank you, Vance, for joining us, all the way from Cincinnati, in fact. So we're very grateful. And I look forward to reading your book and hopefully others on the call. Platt, would you like to go next?
Sure, good to be here. Platt Boyd, founder and CEO of Branch Technology. In previous life, was an architect, and then about 5.5 years ago, left the partnership to found Branch. And we're doing construction scale prefabrication using robotic 3D printing to do commercial construction and facades.
Awesome. And Platt's company just raised a large round, and he's ready to scale and conquer the world. And we wish him the very best. Jim, would you like to go next?
Hi, everyone. Good to see a lot of familiar faces I haven't seen in a long time. I'm Jim Stefancik. So I am the director of corporate development at Cumberland Emerging Technologies, where we in-license technologies. I'm also a former entrepreneur. I had co-founded 2 companies, and I guess I've been on 5 different patents, 5 different inventions. So I've been kind of through multiple cycles of this, and looking forward to trying to help you guys navigate some of this.
Thank you so much, Jim. And for our audience joining today, we actually are very lucky to have a perfect mix, I think, for this panel. So we have an entrepreneur who faces questions about patent protection and legal matters. We have a representative from tech transfer in the university environment. We have an IP attorney, and we have a director of corp dev from an incubator. So it's pretty much the whole ecosystem that you could possibly ask for. And again, so grateful to have you all and spending your time. So how this is going to work, we're going to spend about an hour or so with the panelists, having an interactive discussion, hopefully a lively one. And then we're going to save 30 minutes for questions at the end, where we highly encourage you to ask all the entrepreneurs on the call, or anybody else for that matter, any questions you might have, as that's the whole reason we're doing this, is to help spread knowledge, learning experiences, and to help you grow your companies more successfully as it relates to the world of patents and IP strategy. So I'm going to kick us off just at a high level. So the US Patent Office, USPTO, costs the American taxpayer not a single dime. It's entirely funded through patent application fees. And interestingly, and in fact, it's the only arm of the entire federal government that's wholly self-supporting. In the early 90s, Congress diverted nearly $1 billion of funding away from the US Patent Office, leaving it somewhat understaffed, under-resourced. I had an attorney out in the Bay Area, Vern Norvell, who's pretty well known in the life sciences for patent law. And he used to say something, I'm going to paraphrase here, over the last few years, all my life science companies, they've either been slowed down or stopped by problems in the patent office. That's because, in life sciences, if you're going to bring a new drug to market, it's going to cost $1 billion. The patent needs to be bulletproof or nobody's going to invest. So my first question to the panel is, what is the current state of the US PTO today, and what are your thoughts?
I can start if you want. So, you're exactly right. In the past, it's been the patent office is notoriously slow, right? So, and in some cases it still is. If you start with a provisional patent application, that's not even examined. And by the time you get to filing your utility or non-provisional application, the typical wait right now, the standard track is about 18 months before that's even going to get picked up for a first review. I've had a couple of art groups and kind of the e-commerce SaaS group. I think my longest ever is 52 months. So in that particular art group, by the time that you get that first office action, the technology might be completely obsolete. So one of the things that is great, and everybody here should know this, is that there are ways now to go faster. So there's a relatively new program called Track 1 Prioritized Examination, where you can pay to expedite your patent application. It varies based on the size of your company. If you're a small entity, it's $2,000. If you're a micro entity, it's only $1,000. And they're going to be picking this up now in about 4 months, as opposed to 1.5 years or 2 years. So there are ways to go faster, and your point is 100% spot on. They want the money, right? So that's why they're doing it.
I could comment on that fast track. It's actually a higher educated reviewer or one with more experience. Is that right, Vance Van Drake?
It actually is. So they, the folks in that program are considered the best of the bunch typically. And not only are the applications getting picked up faster, but the allowance rate is higher. That could be a little bit of a causation correlation question, because people kind of willing to spend that money, they care that much, maybe the inventions are better. But the statistics are higher for allowances in that program. And just anecdotally, we're seeing that. For my startups, the money is, my companies either want to go really, really slow, or they want to go really, really fast. And if, for $1,000, $2,000, it's often worth it. And I guess the last thing I'd say about examiners is, they've done a better job. They hired, a couple of years ago, I think another 1,000 patent examiners. They're all allowed to hotel now, which means they're all allowed to work remotely. There used to be, you get to meet with your examiner as part of the patent process, and people used to go in person to DC. Well, the examiners aren't there now. So the examiners are all over the country, working remotely from their computers. That's, I think, enabled them to hire more better people, because not everybody has to go to DC. But at the same time, once somebody's worked for 4 or 5 years in the patent office, they become very attractive, to law firms. So there are issues with experience and quality sometimes, and I tell my clients, if just because you get a rejection, that doesn't mean anything. Sometimes we've all seen some crazy stuff, that gets cited, and it's just the start of the negotiation.
Yeah, I've heard the same from other people telling telling the field that the allowance rate is higher, and from what I've seen so far, it has been. So that's a good point.
Right. If
This
nobody
is
else.
Jim talking here. So what I've seen over the 20 plus years that I've been kind of prosecuting or dealing with patents in different environments is I think it started to get better. I think in the middle of the Obama administration, I think there was a focus on changing. What Vance just talked about was all new to me. I didn't realize. I figured there was more remote. I figured that would be a way they could do this. You know, there's so many good resources out there that you can use to kind of follow your patent and understand the process and work on the strategy that I think most shareholders, stakeholders in the businesses understand that it's going to be, you know, it's going to be a 3 or 4 year process. So then I guess the question is, when do you file? If you have control over the asset, which oftentimes you don't. If you're working for a university, what you'll find is, you know, the university, they, you know, Maha can comment on this, I'm sure, but, you know, they want to file. Oftentimes they have to file more quickly because of disclosure versus if you have a, you know, in your company, you can wait, you know, and you want to wait as long as possible from a strategy perspective, especially if it's a pharmaceutical asset that's going to take, you know, possibly 10 years to commercialize or longer. You don't want the 20-year clock starting, you know, right away. So, you know, if you can keep it as a trade secret, that's, you know, to your advantage. So sometimes, you know, timing is, you know, is not as critical, you know, for your own assets that you own at your business.
Yep.
Great. I'd like to move to the subject of capital, raising capital and financing, which is usually at the top of most entrepreneurs' minds as it relates to patents. So, you know, study after study has shown that startups with patents attract larger and more experienced venture capital investors and usually significantly larger rounds of investment. I was just reading an MIT Sloan Business School study talking about the correlation between strong patents and startup success. And just as an example, you can have the most amazing, for example, medical discovery in the world, and $1 will barely get you on the bus if you don't have a patent that can attract the funding you need to commercialize that discovery and get it into the hands of patients who need it. So, to the panel, to what extent do you see the correlation between patents, the direct correlations between patents and startup success and fundraising?
I don't know generally so much, but I can speak from our experience, and it has been vitally important. And so it was one of the first things that we started even before incorporating the business was the original provisional patent. And then probably, I guess, 9 months later, incorporated the business. And the original conversations with investors, they want to know, do you have defensible IP? And in the early days, you just answer that with saying yes. And here's where we're pursuing that. We don't have any patents yet. This is the idea and where we're pursuing that. But then over time, as you get into higher levels of sophistication on investors, it matters a lot. And it's something that they want to see patents that you have received, and then also patents in process, and then any infringement, and how you're dealing with that. And then one thing that recently came up for us in our B round, which we had not encountered prior, was like a freedom to operate search. Had we done that or not? And so we're in the midst of doing that right now, just from a can we operate? And well, I mean, there's really nobody else in the world doing what we're doing. So it's something that we felt, kind of knowing the ecosystem, that we were okay. It's fairly expensive. And so, but they, for this round, wanted to see that come in place. And so you're trying as much as you can to limit the amount that you spend on the patent front, especially at the early stages, and then kind of delay that investment. But you have to be very, very strategic about how you do that spend with limited investor dollars at the beginning. And then as that grows, then you can expand your IP portfolio. But it becomes more and more important. And especially as success comes, it is like how you create defensibility. And like one firm that we're familiar with, they're probably defending themselves to the tunes of millions of dollars per year because they're very, very successful. And so success generates those lawsuits. And so the more you can establish a foundation that, at the earliest stage, the better you can be.
Yeah.
Oh, go ahead, Vance.
I was going to say, I echo everything that Platt said. I mean, it's, you know, really I kind of divide IP into sort of two separate sides. And the first is protecting your own stuff, you know, really planting the flag and owning your own technology. And then over here is kind of the freedom to operate side, non-infringement. You know, I'll have some startups that come in and, you know, they want to do that work Platt, like right out of the gate. You know, and those non-infringement freedom to operate opinions are incredibly expensive, as you've probably found out. So they're really involved, and they're also related to a very specific commercial version of your product, which usually has not evolved until you're at like a Series A, Series B round. And so what I tell most of my startups is just stick a pin in this freedom to operate side. And if you've got an investor that's asking for that at like a seed, pre-seed stage, they probably don't know what they're talking about. And there's ways to articulate that, but you should not throw your hard-earned cash at that. I usually encourage folks to focus early on just protecting your own stuff. You know, start putting those fences around the IP and the provisional and those kind of things. So that's kind of the first part. And then the second part that's nice and Platt, I think you came across this, is that the patent costs really can be staggered as well. So filing just the first provisional application that lasts for 12 months, that also preserves all your international filing rights just with that one single provisional application. You can tell investors you preserved those rights, and you've done nothing more than maybe pay $140 for that filing fee. The farther you get through the patent process, the more expensive those things get. You know, finally, when you get to that international, you know, patent filing stage, that super long story short, it's usually about 30 months from your first filing date. That's where the big ticket costs really come in, and you're really hoping that's other people's money at that point.
I will say we did do a search in the beginning, like just a patentability search, and that's important, but that's fairly low cost. Then for us, we wanted to defer as much, go as slow as possible because we were in stealth mode, and we wanted to defer those costs as long as possible. So we did the provisional that bought us a year. Not PTO.
PT.
What?
PCT.
Yeah, PCT, Patent Cooperation Treaty patent. So that buys you another 18 months. And then you have to decide which countries, and then that each of those is a year or so process. And so like ours started in 2013. We just got our first patent in 2019. And now we have, I think, 7 in total in different countries. And we've got, I think, another half dozen in process. And like the one that is probably going to be the most costly is the EU, where you get one application that eventually gets approved, but then you have to disperse it into different jurisdictions in Europe. And we haven't gotten through that yet, but that's going to be really expensive when that happens.
Yeah, the foreign filing piece is, I think, just a really good one to talk about in general. You know, I get a lot of startups, and sometimes maybe they start the patent process really early, which has some positives and has some negatives, but they end up getting to that, you know, that foreign filing deadline before they've really raised substantial capital. And that's a really tough conversation to have. So patents are jurisdictional for the folks that don't know. I wish there was a worldwide patent. That would be great. But you've got to get a patent in every single country where you want to have that exclusive protection. And even the biggest, we do Procter and Gamble patent work is in my backyard. And even the very biggest companies don't do everywhere, right? It really becomes a question of, is the juice worth the squeeze? And those costs get exponential really quick. And so, yeah, where you manufacture a key sales market is maybe where you focus. But at the same time, for a lot of startups, for that Gen 1 family of IP, maybe it's really just the United States. And then as you get to Gen 2 or Gen 3, maybe you've got the resources to look at international. But I've seen it sink companies trying to do too much on the foreign side.
Great. I'd like to talk a little bit about trade secrets, when to publish.
We can't talk about that.
When when not to publish. I have a mix of a software background and life sciences, and I know especially in life sciences, and we have representatives from that mentor network here today, sometimes it really doesn't make sense to publish anything because you want to keep that information a trade secret to the company, and it's also really difficult to go back and defend against a larger corporation that you had developed that initially. So today the Patent Office publishes about 2/3 of all their applications for the world to see after they're filed, and it's no surprise or secret that larger companies have stolen startup discoveries. There's even a name for it, efficient infringement, where large companies calculate the benefit of stealing someone else's patented technology against the possibility of being forced to pay damages. So to the panel, what's your advice to entrepreneurs who may not have the funding in order to be able to commercialize their own inventions, or more often than not, to wage a multi-million-dollar war in the courts against a larger incumbent in which, they're just going to bleed that startup dry of cash?
Yeah, that's a tough question, to answer when you consider your capital versus the time frames and where you're headed. I think obviously that the looking at the prior art or the patentability search, I think is really important. You want to look at the world's published literature. If you think you have something, if you're pretty sure you have something, that's when you got to strategize with, find a good IP lawyer to strategize with. That's worth the money early on. And then, that all has to roll up into your business. When are you going to be able to sell the product? Can you file continuation in parts? Like, can you, are you going to do you think you're going to further invent this? Add to, change the embodiment of the invention. But yeah, you always have to, I think probably a lot of the companies on here are in more niche businesses. You don't have to worry about Google or Nokia or one of these guys coming after you probably as much. The pharmaceutical space, that can be trickier. And then of course, if you're working with the university, then you've got the issue of, when is the, depending on the relationship you've had, how long you've had, when is the university going to file, the inventor probably is, publish or perish, right? And so they're going to want to publish what they're working on. We're fortunate that we have really good relationships with longer-term relationships with some of the inventors, and even some stuff we're working on right now. We've been really good discussions with the inventors we work with at Vanderbilt for the stuff we're licensing at Cumberland, to say, hey, let's take a really close look at this before you go out and publish this paper. We know you want to publish. It's going to help you get the next grant. But I think for a lot of the businesses we're in, I don't know if I'd worry as much about the idea of someone infringing on you. I think it's more important to make sure that your investors, whatever you're going to need to get the company to the next level is the most important thing. And that capital is going to, once the investors are in with you, if they do their own freedom to operate, or they do, their own analysis, and they're happy with it and they're married to you, they're in the trenches with you, right? And so they're obviously not going to want to lose their money over an infringement. So I think it's more important to make the potential investor happy and feel comfortable about where you're going with the IP. They've got a lot more experience maybe in your industry on what infringement might look like, and so maybe rely on them as well.
I'll speak about a little bit about trade secrets, and I think Vance, you might be able to speak more about this, but like a patent is great, but you're telling them how to do what you're doing. That's the point of a patent, is someone skilled in the arts can replicate or protect that ability to replicate what you're doing. So if it's something that is very, very difficult and you feel very confident that you don't need that patent because nobody else is going to be able to figure out how to do this, that's a perfect application for a trade secret. And a trade secret is a lot better than a patent. But that means you can't tell anybody. Like Coke has its formula because they didn't tell anybody, maybe just a core handful of people. So if something is that important, you really do have to protect it. And it truly is a secret. And the two people that you tell will tell two people, and that geometric multiplication happens. So you just have to really, really protect trade secrets. So it's rigorous. And then you have to talk to your people in the organization about what is a trade secret, what isn't, how do you communicate, how do you not communicate about those, who has access to that. And then one other aspect that happened recently for us is the attorney for the investment came in and said, can you list out all of your IP and your trade secrets? And we said, well, it wouldn't be a very good secret if we told you about them all. And so if somebody from an investment standpoint asks you to disclose all of your trade secrets, you say no, because that would be just really, really bad to disclose all your trade secrets in order to gain money from an investor.
Platt, can you confirm most investors also are very proudly will not sign NDAs? I mean, that's
correct. Yeah.
So sometimes they even say you've got to sign something that says nothing that you tell us is a secret. So it's super risky with those folks.
It's also interesting from a patent strategy. Vance probably knows that Procter & Gamble, you will not find a patent for Tide detergent. They have a family of patents on families of chemistries. And so claim 4 of this patent and claim 7 of this patent and claim 20 of this patent, all those different strange claims creates Tide, but you won't find a patent on Tide detergent. They hide it in families, in claims of families of patents, but then that's expensive.
Yeah, so just to, please.
Continuing on Gary's point, and I think, Vance, you can continue that not all patents are the same. So you have a composition of matter claims, which is really what probably the different Tide claims are, is the chemistry behind it, to a method claim. And that is sometimes the problem that we have is something is a method. Think about a cookie, but I like to say the composition of what goes into the cookie, if I can get that, is huge, because then I can write such broad claims that I can get any cookie, even the cookies I didn't think of, if my attorney drafts big claims. But the way of baking a cookie is a method, and somebody can come around it. So it's better to keep that as a trade secret, or try and hide it in different patents, very much like P&G did. So good luck trying to figure out how they put things together. And so that is a strategy that, as a tech transfer, we have to think about, which ones do we really want to go after, the utility ones or the methods? And Vance, you can continue on that.
Yeah, that's great. I mean, I agree with all of that. I mean, the reality is for most companies, so the kind of in the order of operations for the analysis, one of the questions we ask is, all right, so this is something that's valuable to you. What's the best bucket to protect it with? So you've got patents, copyrights, trademarks, and trade secrets. A lot of the stuff that's protectable with the trade secret could be patented, right? Most patents internationally last for 20 years. And so the very basic calculus in a lot of cases is, do you really think you can keep it secret for longer than 20 years? If you think you can, then to Platt's point, trade secrets are technically free. I mean, there's protections you got to put in place, but there's no registration, there's no filing for a trade secret, and you could theoretically keep it, own that forever. The flip side, though, is with how good people have gotten with reverse engineering. And you've got to think too, not just what they can do now, but 10 years from now in your patent, will it be even easier to reverse engineer technologies, at that point? So that's kind of the calculus, is can you go beyond 20 years and really keep it a secret? And the other kind of part of the equation, I think most of the companies here are kind of more in the harder tech, where you've got physical components and products that are involved. Those are much easier to reverse engineer, obviously, right? So, but sometimes within your company, you may have some back-end processes, some software, where software is still pretty tough to patent, that runs your systems, where the software maybe is something you keep as a trade secret, but the stuff that is going to be in the public and reverse engineerable is where you pursue the patent on that technology. And the last thing I'd add is, in the book, the second half of the book is all patent strategies. And there's actually a perception that you can't kind of have your trade secret cake and eat it too. But there really are two ways that you can do that. And kind of giving the audience, I'm just going to be real quick. The first is that your patent application won't become public until 18 months from its initial filing date. One of the things that we've done is, I mentioned the track one to go really fast. It is possible now to file your patent application, go rocket fast while it's still totally confidential, and see if you can get the patent claims that you want before it becomes public. If you can't, you may be able to actively abandon that patent application so it doesn't see the light of day. So it's a little sneaky. The other is that a provisional by itself is 100% confidential. So somebody like Jim, and it also doesn't start your 20-year patent term. You can file a provisional application and you've got a year. If you just let that, you do nothing, it will go abandoned. It will never see the light of day. So I've had some clients that are like, listen, we think we want to keep this as a trade secret, but we do not trust our salespeople. so we'll file a provisional, not tell the salespeople, and tell the salespeople it's a trade secret. And then we've had a couple of instances where we get past the point and they've said something at a trade show and we fall back on our patent protection. If you file internationally, your application has to publish. But in the United States, if you're only focused on the US, when you file that non-provisional application, you can check a box cleverly called the non-publication box, and your application will not publish if and until it issues as a patent. So if you want more time and you're focused on the United States, there is a way to kind of keep that trade secret option open until you're going to get the claims that you want, because Platt's 100% right. You have to totally teach your invention. And the worst case scenario is you teach the entire roadmap and then you get crap claims or no claims, and now you've just published the whole thing. But there are ways to sort of mitigate that risk by either going fast or focusing on the US. So a little Yep.
Vance, quick question. I didn't realize, maybe you can clarify for the audience too. So when you file the provisional, that isn't one of your 20 years. You have 20 years from a year after that. So you actually have 21 years with the provisional?
That's exactly right. So actually, in the book, I know, shameless plugs. One of the examples I use is pharmaceutical companies will often, provisionals have a reputation as being kind of a subpar quality filing. The reality is that it depends on the type of company that you are. So a pharmaceutical company may file as a provisional the full application. It's ready for prime time, right? But do it solely to not start the clock on the 20 years. So you'll see pharma companies do the provisional. It's this gorgeous application. They'll wait until the very last day of the 12 years, then file that non-provisional application, and that's when the 20-year period starts.
Yeah, I would also comment on what you said about reverse engineering hardware and hardware patents being the I guess the easiest to reverse engineer. And that for a previous employer, like I was asked, I have a design engineer background and I'm still pretty early in my career, but we did that all the time. Somebody would come out with patents that's a competitor of my employer, and I'm asked directly to look at it and find a hole in their claims and make something that does the same thing. And we did it all the time, and it's pretty easy. So like, what would you suggest, with hardware? Like, because you can't really keep it a trade secret, because someone could get a hold of your hardware, take it apart, and do exactly as I've done for previous employers. Like, what's the best method, you think?
So I feel like I'm talking a lot, so shut up. I'm a lawyer.
A lot of good answers.
It's what we do, right? So it's a great question. One of the strategies that I love is there's a common misconception that when you file one patent application, it turns into one patent and you're finished. That is absolutely wrong. So what you can, one patent application that, let's say it's got 10 different embodiments versions in it. If you get kind of a first patent that's allowable from that, as long as before that patent issues, you can spin off, we call it a continuation or a divisional application, a carbon copy of the original filing to build something else out of the bucket of Legos that is kind of the rest of the stuff that's in your patent application. Yeah. You can keep that alive and malleable for the entire life of the patent. So, for a lot of my clients where we know somebody's going to design around, totally legal, our claims, you having a pending application where you could build anything out of that application into new claims really creates a headache for your competitors. They love it. Fixed claims are great. They're like, okay, A, B, and C, we don't do B, we're done.
Right.
But when they have to look at your specification and your drawings and be like, oh man, if they ever try to claim what's in figure 27, right, we're toast. Is a great tool. And so, usually we'll find something valuable to do in a continuation, but I've kept continuations alive just to keep that threat going. And that's the counter attack to the design round.
But you're not, I always assumed you were specifically tied in continuations to those original figures and embodiments that you included in your primary application, right? There's no way you could write a continuation with a new set of claims that doesn't reference one of those figures.
So sort of, right? So kind of sticking to the example before is a straight continuation is right. It's a closed universe. And I use the analogy, it's like a bucket of Legos. Everything in your application's in the bucket of Legos. And when that gets filed, you can't add any more Legos to the bucket. With continuations, you can build different things using those same Legos, but no new Legos go into the bucket. As long as you do that, you get priority all the way back to the beginning. So this is the really important thing, right? Yeah. You're building something new, but it's got priority back to maybe your provisional filing date. Yeah. There is a tool called a CIP that Jim mentioned, a continuation in part, where you can add more Legos to the bucket, but those new Legos, it's logical. They don't get priority back to the beginning, right? They get the priority from when they were added to the bucket. So So there's ways to do it, but it's not this magic bullet where it's like, oh, I've got this great idea. It's going to go back 4 years in priority.
Great analogy.
The way that we've thought about what you're talking about, like mechanism, I put it in 3 different buckets. One is a product, second is a mechanism, and third is a process, and kind of in that order of precedence, because the product can be made. If you have a product, then it could be made any which way, but if it looks like that end product eventually, it doesn't matter how they make it. You've patented that thing. And so for us, that was the cellular fabrication and the wall assemblies and like what can be made with this 3D printed matrix and how you fill it. And so that's our product patent. The mechanism is how you extrude that and 3D print with that. And then the process is like the process that all that goes through. And so it's a whole lot easier to go around a process than it is to go around a product. So I just, if you have something that it enables a certain end product, that's probably a better way to go about than the mechanism.
And Platt, did you spin those all out of kind of like the same application to get multiple?
Oh yeah.
Yep, that's the way to do it. Yep.
Well, no, we were forced to do it. We didn't want to do it because we said, look, our product is a result of a mechanism that goes through a process. It's 3D printing. You can't unmarry those things. So, but the patent office thinks, and they want the funds for each of those, and so they make you separate it out into those different children. But it all started as one application.
Yeah, we've almost stopped at this point, Platt, putting method and apparatus claims in the same application because they will, for those, it's called a restriction requirement. They'll tell you, oh gosh, you're genius, Platt. This is actually 2 or 3 separate inventions. We encourage you to pay a separate filing fee to pursue the method associated with your apparatus claims. And it's a little bit of a scam.
That's how they're self-funded, right?
Yep, and you can't really fight it. That's the long story short. So
USPTO bag of tricks.
Oh yeah.
I'd like to switch gears here for a minute and move towards looking at patents as assets that can be used in a business competitive setting. For example, to driving top line revenue and licensing. And I'd love to hear a little bit from Maha and Jim on this, but in general, revenues from licensing of patent rights, they've skyrocketed in the last few decades, from around 15 billion to hundreds of billions of dollars today, and can be among a company's most flexible, valuable assets. I think TI was one of the first in the 80s that was on the verge of bankruptcy and did portfolio mining and turned around their situation. And today, I think they've earned more than $4 billion in patent royalties and have a steady income stream of 800 million a year or so as of today. So Maha, could you speak to licensing and royalties from a university tech transfer perspective? And Jim, perhaps you could speak to kind of licensing models in the free market for startups.
Yeah, so the most important thing, we had a great discussion on patents, great 101 on patents and how broad you write them. But the broader you write your claims, and this is something from a licensing, and that's why they could go back and mine it. If, I've had this, researchers have been working on A composition, but when the claims are written, a good attorney is going to write really broad claims that not just covers A, but covers B, C, and D. Now, it may very well turn out that, so when we license it, it's called a field of use licensing. So it may just very well be that if your field, Platt, I'm going to pick on you. I don't have any colonial patents. I'm just going to randomly pick on you right now, is that you have everything with the 3D extruder and all that is your biggest, focus in your market. but what you have in your composition claims and some other claims can be applied to, say, injection molding, which is a completely different way of manufacturing. Then you could technically, even without competing, license that to another company and tell them, hey, you can use this in the injection mold space. So one of the ways you can do it is using a field of use. The other way you can also think about licensing, especially when it's an ag tech or pharma, but especially in terms of ag tech, because I see a lot more of that, is with countries. So it may just be that US is a huge country and we want to focus, as UT at the startup at US, but Brazil is another huge country in ag, and I may actually find a partner in Brazil and I may license for them to do it in Brazil. But because of this, that is great because you can leverage. What you can also do is cross-license. And that is where it can be, I can use your patents for mine and mine for yours. But what you get through all of this is revenues, especially when you're licensing it outside your field. I was talking to a sensor company which senses stuff for animals. It turns out that their sensor patents is so broad that Fitbit was interested in licensing because Fitbit needed it as a freedom to operate. They did their analysis and they realized they needed this company's patent. Totally unrelated, right? Fitbit is what we all wear, and this company is only focused on animal health. So they were like, great, we can license it to this company and make money out of human sales. But as we learn more, we can develop here. So that is a great strategy. So when you think about it, think about partnerships in terms of territories, geographic territories, think about it in terms of field of use, and then think about it in terms of cross-licensing. So it just may be, when you go back to freedom to operate, maybe I need some of your patents, you need some of mine. Let us see if we can get into a license agreement. This is mainly done with big companies. So these are the different avenues. And then you get money as a university. We can either license it for different field of use, and that's great. So we keep getting royalty streams there. But more often what happens is we give it to a startup, which has it in all fields with the right to sub-license. So we see sub-licensing revenues. So that's how the university makes its moolah. But that is also something that as a company you can think about is maybe I am, this medical process is used for, I'm only concerned about the heart, but hey, company, J&J, you can work with this technology in the brain. And here I give you a sub-license to our patents and let's all go. And so this is, sub-license or field of use license is something that we think about a lot. And so when we ask for business plan on startups, we are we do want to understand the field of use.
It seems like that'd be kind of hard to enforce. I guess like if you have a field of use or say, like you mentioned, geographical territories where you license a technology to a company that, okay, you're allowed to sell this Platts 3D printing tech in North Dakota, for instance, and that's trying to control a company's sales team, I guess I just have a question on enforceability and how that works.
So typically, geography works when you are in which you can't control. What is easier to control is when you have different field of use. And this is where field of use gets really tricky, is how well do you define the field of use and how broad do you define it so you don't accidentally overlap. It's very easy for me to tell you humans and non-human animals. That is easy. If I just tell you animals, technically humans are animals, but what kind of animals am I looking at? And so when it comes to agriculture, I have to be very specific in the kinds of crops. So I have given company A soybean and I give company B corn, two different ones, easy to enforce. You have to be really careful. I was working with an aerospace company and they said, oh, we need it for this aerospace. I'm like, great. They sent me a one-page definition of aerospace. I'm not kidding. Wow. I still have it. A one-page definition of aerospace. I'm like, oof. Same thing. I'm working with an automotive company. It was half a page definition of what constitutes automotive. So yeah, you've got to work with an attorney, and you have to understand and get those definitions right, because that is the one that, quite honestly, the tech transfer, if I'm doing field of use, I spend the most time thinking is, how do you define that so that I create separate and don't accidentally overlap? Because if it overlaps, as a university, I'm liable.
Most important part is you're saying verbiage in the license agreement and field of use. Okay, got it.
Yep.
I think I would think about it a little bit from the sub-license that Maha mentioned. So a lot of the assets that we're in licensing at Cumberland, it's going to cost, if we have six or seven different projects we're working on, we would need hundreds of millions of dollars to get all these to market. It may be that one or two of them, we raise the money, we, we do it as a publicly traded pharma company, we bring it to market. But other ones, we're definitely going to want to partner, with much bigger pharma. So when you're working on this license agreement, you want to think about, all entrepreneurs, go in with very wide eyes. Hey, I can go out, I can raise 15 or $20 million. You hear about it all the time, right? Well, it's really hard to do that. It's really hard to do that. It's even harder to do that, in our region of the country. There's just not that kind of capital or the experience to take these assets all the way through to market. So there's a good chance you're going to partner with somebody. So you're going to want to think about the asset that you're in licensing. How strong is it? Like I said, later on, if you partner with a investment group, you're married to them. They're going to want to, they're going to want to defend it too, because all their revenue may depend on the value of that asset. So, you're going to want to do as much due diligence as you can up front, have very clear license agreement, but also, you want the university to be flexible, Maha. You want them to be, if you partner with someone that they want to change something, can you amend the license agreement? If you find the right partner down the road, you want to make sure that there's the opportunity for some flexibility there. The university's fine, if they're going to own a smaller piece of a bigger pie, or the opportunity, the only way for the opportunity to move forward, it's either zero or this happens. It's a binary event. That happens a lot. That happens a lot to companies. And so, you want to understand the partner. What's the partner going to get out of it? It's possible that they're putting a lot more skin in the game than you're able to raise to get the asset to generate revenues. Because like Maha said, the goal, a lot of universities, their goal now is to get things out there. They don't want a lot of upfront. They like it if they can get a little bit upfront, of course. They want their patent recovery costs. They want, they would love to get some milestone payments or some licensing fees, but they understand, they don't want to hamper the company. But when it's successful, they want, everybody wants their share when it's successful. And so the more you can think about that, I think a lot of the companies in this network are working with these kind of assets. These are not things you're going to build an app and you're going to start generating revenue next year. We're talking years before it generates any revenue. So
seems like it'd be big in the pharma industry, especially with a pharma company that has large manufacturing facilities, columns to elute, specific drugs. Somebody has IP, and that partnership makes sense. But maybe Jim or Maha, do you think what other industries is this kind of big in with maybe top three with this licensing and sub-licensing agreements?
Pharma's got, I've only been in the pharma space now for about 1.5 years, and compared to the device space where I pretty much cut my teeth, it's not even close to the amount of capital and risk. And you build very sophisticated models on what is the value of the asset today based on the risks going forward, and lots and lots of variables. And that's how you eventually come to a deal. Eventually there has to be a number, but that almost always involves big pharma. You're talking the top 20 companies that have, tens of billions of dollars that they can risk on this.
Right.
Obviously, anything that's highly regulated, any industry that's highly regulated, is going to be.
Ag is one. that is heavy in licensing and sub-licensing and cross-licensing. I don't know how many people are in ag, but if you have ag, there is something called as plant utility patents and PVPs. That's a whole other ball game of how you would protect different varieties and move forward. And plant is, and so ag is used that, but I'm also seeing it more and more.
What is ag? Oh, I'm sorry.
Agriculture, I'm so sorry, agriculture. Okay. And the other place that you see this is in chemical companies. I actually had a colleague of mine from Dow Chemical who called me up and said, hey, there is a big pharma company that says, you know, their product may infringe on our big chemical claims. If you think about it, it kind of makes sense. And so it is, again, big chemical companies. So wherever you can write, and I'm going to go back to if you can write these big, broad composition claims, you know, and then that is where you have so much value. You know, if you get these big composition claims, go after them and make sure and work with your attorney in writing the broadest specs possible. That's what we tell our faculty members when we work with them, you know, and like, think about everything under the sun that you would possibly think of without violating the laws of physics, and put it down there. Because the more we can, at least put it in the specs, because you have created a prior art for someone else. If not anything else, you have prior arted someone else. You know, and there are times when patents have gotten dinged because it was on a flow battery, but somebody in a lithium battery, which is two completely different chemistries, had put that this will also work in a flow battery, and the patent examiner just got stuck up on that. And I'm like, we were banging our head against our wall, and this is where you have to get a better patent examiner too. But it doesn't matter, you know, just because that couple of sentences in that patent and that was it, we couldn't get our patent application issued. So write broad specs.
They're also the hardest, right? Vance can probably, or a couple of you can probably comment on it. You got to put on the biggest boxing gloves with the examiner when you go as broad as you can versus something that might go through quickly on a fast track where it's pretty narrow and the search is easy and it's immediately through versus trying to put on your boxing gloves for a much broader claim set and possibly not even getting anything from it.
Sorry, I was going to say, if you want to answer that question, Vance, real quick, I thought it was a good transition point actually to move from offensive top line revenue strategies to more defensive strategies. But if you want to answer that question really quickly, please go ahead.
I would just real quick is that there's no question that Maha's comment that at the end of the day, the broadest possible patents are the most valuable. But sometimes one of the strategies I use sometimes called establish a beachhead strategy, where, if you're raising capital, you just need to check that box for the investors. Sometimes patent pending checks that box. Sometimes they want to ask you though, do you have a granted patent? And maybe having a patent quickly, even if it's a little narrower, can really check that box and show that, listen, there's novel stuff in here where maybe you're using a continuation to go after the broader stuff that is, to the boxing glove comment, is going to be maybe a protracted fight with the patent office. So there's different ways, kind of depending on the business and the funding goals, to kind of ultimately get to that end result. And the only last thing I'd add is that, broad claim, the best claim to sue an infringer on is the narrowest claim that they still infringe. And the reason for that is that you sue somebody, you think you got this really awesome, super broad claim. The first thing the other side's going to do is say that was invalid. And we talked a little about examiners. Generally, they're great. But sometimes examiners let through these crazy claims that they just shouldn't have. They didn't do enough searching. They didn't see what's out there. And we're all probably aware of patents. We're like, how the hell did they get this, right? Yeah. It can feel great when you get the super broad claims, but those may be subject to attack in litigation. So sometimes having narrower, super valuable claims can be kind of a nice tool in the toolbox, but agree with everything that's been said.
I'd like to.
This kind of gets to Brad. Oh, sorry. One real quick point on Vance's comment there. basically investors can find any reason to invest or not to invest in you. If they are just happy you have a patent and that checks the box, great. If they're going to get really into the patent and to the nitty gritty, anybody can do that. So you might want to think about your technology and how it's going to be positioned later to raise money as well.
Gotcha.
Thank you, Jim. Yeah, I'd like to move on now to more defensive strategies with patents. Things like patent walls and clustering and bracketing. I mean, the classic example that comes to mind for me is the Gillette sensor shaver that promised a closer, more comfortable shave because of its twin independently moving blades. The tech behind the innovation was called floated angle geometry, and if I recall, the engineers at Gillette went through seven versions of this blade, and in the end, Gillette's entire patent attorney and R&D teams took under a full patent analysis of these 7 versions to determine which was the most protectable. And in the end, they came out with 22 patents for this particular blade. That's more on the patent wall kind of defensive strategy. Bracketing, on the other hand, is a situation, as some of you may know, and Vance can probably expand upon this, where if a competitor of yours may have a patent on one aspect of a particular process, you can go and patent the entire rest of the components to block that competitor from really getting into market. And so I'd love to hear thoughts from the panelists on using patents as defense in the market. Maybe Vance, that's a good one for you to tackle.
Yeah, so one of the kind of important things to know for companies is that you don't have to have built or ever build what you get a valid patent for. You know, people who take this to extreme are given the pejorative term trolls, right? So this is your intellectual ventures. They don't actually make anything. They just hold a bunch of IP and then they go around and extort money from infringers. If they're our clients, we refer to them as non-practicing entities. In your own work, though, in your own filings, you know, sometimes the most valuable IP you'll file is something that a competitor cares about more than you care about. So, you know, let's say you're kind of focused on your commercial version, but you're like, you come up with something, you're like, man, if our competitor's version had this, you know, this would really gum up the works for their invention. Whether or not you ever commercialize that is not a requirement, as long as you know how to make it and you can kind of teach that in the patent application. So I encourage kind of, you know, founders to think outside of just, you get laser focused on what you're building, but there can be value in these other places. And then kind of in terms of the wall, you know, I do this a lot with my medical device clients, where the art is really dense, and, you know, out of kind of one really big patent application, you know, we might spin 20 patents out of that initial family, and some of it might be kind of A prime, A double prime in the claims, and the idea there is, you know, it looks intimidating, right? It's kind of a big thicket. But then it's also a defense if people are going to challenge the validity of certain claims. So, you know, in dense art where people are going to come at you with invalidity attacks, the more things you have for them to have to kill makes their job a lot harder. And, you know, the vast majority of patent litigations settle. Only of all that are filed, only 1 to 3% actually go the distance. So defensively, you know, a lot of litigation is about saber rattling. It's looking like it's going to be more expensive to fight us than it is just to write us $100 million check. And so it's a lot of that defensive game. And then the last piece with the wall is that, and Maha kind of mentioned this, is cross licensing, right? if you've got stuff the other side wants, just because you've got a bigger repository, sometimes you'll see horse trading. And what, these are frenemies. What started off as a contentious lawsuit turns into an exclusive sublicense between two companies that are like, you know what, we're going to be buddies and to hell with everybody else.
All right, we've got a couple of questions in the chat that I want to make sure we get to before other people can also weigh in with questions. So the first question we have is, would any of the panelists be willing to share any important lessons learned with the Patent Cooperative Treaty?
I don't know about lessons learned so much, but just when you do a PCT filing, which we've done for our major original filings, it gives you 18 months in addition to the 1-year provisional. And then in that 18 months, then you can decide which locations that you want to file it in at the end of that 18 months. And so that it can be a time buying strategy. And for us, that was important. It also is a deferment of investment. So that really gets you 2.5 years before you're really having to spend a pretty good amount on that. And then the other is you have to choose, okay, if you're going to go after a particular, well, if your invention has value, you've got to determine what countries are going to buy that value, and is it worthwhile to pursue that country with that value? And it's a value judgment on that. And so you've got to figure out where in the world, what markets are appropriate. So that's something that you just have to, it's a value decision at that point.
So one thing to understand is that not every country belongs to the PCT. So especially for people in the space of agriculture, Argentina, which is a huge ag country, is not a member of the PCT. So you have to file, a PCT and an Argentina at the same time. The other thing what I like about a PCT is you get a search report, that they actually give you a search report. You can pick a country, how you want to get the search report done. But what that does is it kind of, there's a patent examiner who does, some work and writes up a report, but you get to understand what the prior art from a patent office is telling you and what kind of objections, that you're going to see and how easy or how difficult it is going to be to overcome. And sometimes you can actually modify your claims if you want to when you enter the national phase to take care of those objections. So that is something that personally we have found really useful and leveraged quite a bit as a search report.
Well, I don't think I follow you. So the timeline would be file US provisional, file PCT to get the search report, and modify claims in each country after that, potentially?
If you want to, yeah, depending on which country you want to get in. You don't have to, it just gives you a heads up if you want to. Sometimes if you have a licensee, they do request that, but that is interesting. Yeah.
Got it.
There's a really important program that hopefully some of you have heard about before, but it's shocking to me how many people have it, even that have patents. It's called the Patent Prosecution Highway. So it's this awesome program where all these countries got together, kind of like how they agreed with the PCT. All these countries got together and they were like, listen, if the United States Patent and Trademark Office considers this patentable, why should we in Canada spend all the resources to do all this same review to grant the patent?
Yeah.
And so what you can have is, let's say if you get allowable subject matter, so not even granted, but allowable subject matter, a ton of countries now have these cooperative PPH, Patent Prosecution Highway agreements, where you can get picked up rocket fast and a lot of times rubber stamped as a patent into that country. My absolute favorite is Canada. Canada sometimes is less than 2 months from when you go into Canada and you're like, listen, we've got these allowed claims in the US. Canada's like, we love the United States. We trust you guys. Here's your patent. So,
so you said allowable subject matter. Does that have to be an independent claim, or could it be dependent claims, or vice versa?
It could be. So a dependent claim would require rolling in the subject matter of the independent claim. So if you got, if claim 2 is a dependent and it's allowable, 1 plus 2, then you could go into a Canada and say, listen, your work is done, Canada. Grant us the patent. And that saves so much money in foreign prosecution. Looks better because your international patents are getting granted so fast. And there's so many countries that do this now. And the reason Maha kind of triggered that, you can also do this off that PCT search report. So as part of that search, if you get what I call a clean search report, so novelty, inventive step, and industrial use, if there's no issues with that, you can use that search for the patent prosecution highway into a ton of countries to get rocket fast patents. And it's just awesome.
Patent prosecution highway is what you called it?
Mm-hmm.
Yeah, I'm going to need your book, Vance. I'm going to need 5 copies.
We'll have it
Hey, wait, we get royalties off of that. Hello.
Now we're talking.
I have to get to Gary's question. My apologies, Gary, for the delay. He's been asking for some time. Can we talk a little bit about international country strategy, Vance? You touched on this, and that was the tail end of a little bit of this conversation. And then I'm going to group that with another question that came in with a hypothetical scenario about international patents. So if my invention has value in Brazil and I patent it there, can an Italian company, for example, make and sell it in Brazil without infringing? Could they sell it in Italy if I don't have a patent in Italy without infringing? So
it's a great question. So a patent is a right to exclude, right? So you're allowed to exclude people from making, using, selling, or offering to sell the invention within the country that you have the patent protection. So if I have a United States patent and only a United States patent, somebody in Brazil could absolutely copy my patent. If they make it, use it, and sell it in Brazil, there's nothing I can do. That's totally legal. If they try to import it into the United States, though, I can actually tell customs and have the stuff seized at the border. So it prevents the import of those products. But it also then, it doesn't matter where the company is based. So it's where the activity is taking place in that make, use, sell, or offer for sale categories. That's what you have the right to exclude. So, Platt mentioned this kind of before. This is the whack-a-mole. You're not going to pick every country. Somebody can absolutely, let's say you leave out Brazil, they make it there, but they can't import it into places where you have patent protection. Does that answer it?
Excellent. I'd like to also open up questions to people on the line to just feel free to speak. You don't have to put it in the chat. So, questions for our 4 brilliant panelists. Don't be shy.
Sorry, I've sprinkled mine throughout the whole talk. But it's been great. You guys answered every question I had.
I have more, so I can keep going, but I don't. I want to prioritize our mentor network participants.
Well, so for many of us on this call, we work with early stage startup companies who typically don't have much money. Now, I get if you can't afford to patent your technology, then maybe you shouldn't be in business. I get that piece. So it's just more of a rhetorical comment. The more you people with patent experience can help startup companies with a strategy that, your point earlier, Vance, about patent in the US only and be happy, for most of these technologies, that's just fine. If they make it and sell it in Brazil for most of these technologies, who cares? So the more you can help us with guidance to guide these early stage companies on a patent strategy to help keep their costs down. I had an original question about a strategy for international filing. I get the basic strategy. You do EU, and depending on your technology, you might do Brazil, and you might do China, you might do Japan, but most of the rest of the world, if they make it and sell it there, you don't care. You know,
Yes,
the cynical
is that in your book?
And you know, the cynical approach is your patent is only as good as your ability to defend it. So you know, that's the other, that's the ugly side of that piece. One of the tricks that we used in my past life at Monsanto is if you make a product, you put a secret ingredient in the tracer. So if somebody actually does make your product and it doesn't contain a secret ingredient, then you've got a little bit of ammunition for patent infringement. But that's just all court attorney fees that you'd like to try to avoid. So the more you guys can help the small companies with a strategy without it getting to be overly expensive, we embrace that.
Yeah, I'd say about half the strategies in the book are all just for startups. You know, there's one that I call the call my bluff strategy, where you can literally file a PowerPoint presentation as a provisional patent application. We gotta, you know, as a deterrent, because it's confidential, for $70, you know, as long as me and the entrepreneur are on the same page, you know, let's say it's a SaaS product, probably not patentable, but they want to say patent pending in a demo day. There's all kinds of little games that you can, you know, too many patent attorneys are, it's $20,000 or it's nothing, right? And, you know, another strategy we do pretty frequently is do kind of a decent provisional application. It's not the Cadillac, but do something to get it on file, where we file then another provisional maybe as soon as they get funding, right? So they got to check the box. Maybe we'll even eat some of the fees as a law firm to kind of help them get there. But then, you know, because it's that catch-22, right? They're like, I need the IP to get the funding, but I need the funding to pay for the IP, right? So how do you break that cycle? What's nice is, just as one kind of little last strategy point, is you can bundle together as many provisionals as you want into that non-provisional that you file at 12 months. And so sometimes what this means is kind of, we have a first provisional, maybe it's just a couple $1,000. It's not great, but it's not nothing. We do a better one in 6 months and then wrap those up together into the non-provisional and the PCT, and it's got priority to both. The most I think I've done is 12 provisionals that we've all bundled together to kind of capture that iterative development of the technology. But there's ways that you can get clever here to try to defer the cost, Gary.
Well, that's also why I always coach for every startup company, when you're ready to do patent strategy, to actually talk to a patent attorney. Because for what you say, you will often have a meeting or two for free or almost no money to give them some really smarts. Yeah, anybody can file a provisional, but use a patent attorney. I'm sorry, Maha, go ahead.
No, but the other strategy that we have used is repeat filing of the provisional. If no publication has happened, you know, and the grant did not go through, so we have filed a provisional and nothing has ever happened in that year's time, then we have gone back and refiled the same provisional. So you restart the clock, and hopefully the second or the third kickstarting attempt, things pick up and go. So that is yet another strategy that startups can use, and they can constantly keep having patent pending.
Great, thanks.
Oh, wow. I
And
didn't
one
know
of the
you could
things
do
about
that.
You also hear about, you know, you hear this papering the walls with provisionals. I think you got to be careful there as well. You know, the provisional, you know, because this gets into stuff that Vance can probably comment on, but we've seen in the past, you know, you want to make sure the provisional is enough of an embodiment of the invention. It doesn't have to have claims, but it has to be an embodiment of the invention so that you can file the full patent. So, you know, and it's not that expensive, right? It's not that expensive to spend a little bit more money, like Gary mentioned, if you can't spend, $500 on this to try and get this filed correctly, and then, take breathe a sigh of relief and be like, okay, I got 12 months now. I can figure out what I want to do for the next 12 months on this. A lot can happen in 12 months, as we all know, in the world we live in today. So, I think that's really important as well, not to just go to Patent Zoom and file a provisional. Talk to a patent lawyer. We have enough in our network here in the state that, you should be able to make 1 or 2 phone calls and find somebody that will give you that time.
Yeah, and you want to find somebody too that does patent work with early stage technology companies. It's some of my partners, they typically work for Fortune 500 companies. Their resumes are just beautiful, right? They're super technically savvy. It's a different game than when it is for startups, and those folks are used to sometimes unlimited budgets. They're going to have 150-page patent applications, and sometimes for a startup, it's not what they need for the business to kind of, reach that first step. So yeah, it's measure twice and cut once. Think through this stuff ahead of time, plan out your whole strategy and how it's, always got to drive value for the business, right? It's not an academic pursuit. So.
Right, thanks.
Yeah, a couple other things on that is I would encourage just anybody that is, if IP is a significant portion of the company, that they work with somebody that is their exclusive focus, that not working with a firm that does divorces, business law, and IP over here on the side, and but that the firm itself, that's their focus, is that they do IP, because I've seen some friends go like, oh yeah, I do IP. Like, no, your firm is doing all these other things. So just choosing the firm is important. And then the second thing would be one thing for us that our attorney made a suggestion, and it was good advice, was, look, you guys write and draw everything. We'll edit, and that'll save you spending however much the attorney, Vance, I don't know how much you charge, but it's in the multiple hundreds of dollars per hour, and normally multiples of what a normal attorney makes. So it's really expensive. And so if you can technically write and draw that, and then let them do the claims, let them do the editing, and then add things as needed, you'll save a ton of money.
Especially for that kind of first provisional or two is a huge help. We like to add to that kind of a recorded invention disclosure call where we'll transcribe it. And the last thing is a lot of what we need, guys like you, Platt, have already created for other purposes, right? Sometimes we just need access to a share file or a Dropbox, and we can get in there and fish around and not distract your team from the real work that's going on. And then the last part, sort of in terms of billing, for all of you startups and for the coaches of startups, encourage your companies to make the attorneys give you caps or not to exceeds on these projects. Attorneys love to let the clock run, bill you 0.12 hours for sending an email. I love with my folks, like once we agree on scope, I'm like, listen, you need a Honda, 2015 Honda Accord version of a patent application. It's pretty good, not a Lamborghini. We're going to cap it at 5,000. Everybody's on the same page. Attorneys should be willing to do that. And if they don't, they probably don't work with startups.
We got a few minutes left. These may be these are problems that I personally encountered as an entrepreneur that maybe we can squeeze in. About 7 years ago or so, the U.S. switched from a first to invent to a first to file system, which definitely weighted advantage towards larger companies, which could throw insane amounts of applications at the U.S. Patent Office, and we didn't have the financial resources to compete. Same with post-grant reviews, where if you guys are familiar with that, it gives the opportunity to to challenge the validity of patents, and larger companies can just drown you. I wonder, in the few moments we have left, someone could talk to those points in the event that an entrepreneur here finds themselves in that position.
I love the knownness of the first to file. I mean, it's cut and dry. And prior to that, we weren't in the market prior to that, so I'm not too familiar, but I can understand. I mean, good grief. You have somebody come out of the woodwork and say, oh, actually, I had this from 1992. Here's my notebook, and here's it signed, and blah, blah, blah. And like, well, that could just come, anybody could do that. So the first to file is for us, it's a comfort, and for investors, really. It gives a lot more just knowability.
Yeah, no more mailing yourself, a self-addressed envelope, right? Or, and big company, a lot of folks who worked with big companies probably remember design notebook days with really strict, rules for when you cross something out and getting witnesses on every page, and all that stuff's really become meaningless now in the first to file. So a group plat, that was perfect. Only thing I'd add is that doesn't mean somebody can steal it from somebody else. So I get this question a lot where it's like, oh, I told somebody even under an NDA and they ran off and filed it. Now they're the quote first to file. No, that's still you can't derive it from somebody else. So it's a race between people independently developing the technology. There it's a first to file, but it doesn't mean somebody can steal it from you.
So Vance, do you think that means with the first to file that filing the provisional is more critical? I mean, that seems to be logical, right?
Yeah, so just super important, and Maha kind of alluded to this, but I want to make sure everybody knows this. So in the United States, when you have a public disclosure of your invention, so a sale, a trade show, a professor publishes a journal article, you start a 1-year clock running. So you've got to file a patent application within that 1-year clock. If you care about foreign patent rights, nowhere else is as nice as the United States. They have, everywhere else pretty much has what's called absolute novelty. If you have a public disclosure even 1 day before you file, and a US provisional would solve that problem, you completely lose all of your foreign patent rights. I've come in to teach at accelerators and universities after the demo day and after the trade show and the science fair, and there's a lot of oh crap moments. So be super cognizant of that timeline. But between that and Jim, to your point, getting that first provisional plants the flag, starts that filing date, and then also might give you some more freedom to disclose it publicly, so you're not messing up those timelines.
Fortunately, we are out of time, right on the clock. I really want to thank our esteemed panelists, Vance, Jim, Maha, Platt. Thank you so much for donating your busy time to this discussion on IP strategy, and I hope it was of benefit to the Mentor Network participants. And Al,
Absolutely.
I'm sure if we can provide, or if the panelists can provide, contact info in case there's follow-up questions. And again, my sincere thanks to everyone today for joining, and especially the panelists.